And now let's go back to our top story. A federal judge has quashed a pair of grand jury subpoenas sent to the Federal Reserve Board. They were part of a criminal probe by U.S. Attorney Jeanine Pirro's office. And in his ruling, Judge James Boasberg said the subpoenas were a pretext to pressure Fed Chairman Jerome Powell to lower interest rates. Pirro responded to the judge's decision in a combative news conference. CBS News Justice correspondent Scott McFarland joins us live right now. Good to see you, Scott. Can you walk us through the judge's decision and what it ultimately means?
Oh, pretty blistering decision from Judge Boasberg, saying in so many words that these subpoenas shouldn't even move forward, much less a grand jury convene to consider evidence, much less a criminal case be filed here. The judge is also saying that this appears to be politically motivated by the White House, that there was not sufficient, if any, evidence of a crime, and that it appears to be an attempt to try to leverage the criminal justice system to get the Federal Reserve Board chair, Jerome Powell, who you see, to lower interest rates, as Trump has been calling for, or to simply resign.
All right, guys, Dr. John here. So let's get started. A federal judge has done something no judge in American history has ever done: transmitted the full evidentiary record of an active trial directly to Congress with an explicit written recommendation to impeach Donald Trump. Not a hint. Not a footnote. A direct formal call for impeachment backed by sworn testimony and documentary evidence. This didn't happen during Watergate. It didn't happen during Clinton. The wall between the judiciary and the political branches has stood for over 2 centuries.
And as part of his argument, in his opinion, the judge presented and iterated Trump's own Truth Social posts in which he claimed Jerome Powell was too late or too slow on lowering interest rates. It's a pretty damning opinion from the judge here, though the U.S. attorney in this case, Jeanine Pirro of the District of Columbia, says she plans to challenge it, appeal, and try to proceed with some type of criminal investigation of Jerome Powell.
Okay, and Scott, I have to say, this is your last day here at CBS News, so any final thoughts before your last hit for 24/7?
Well, I think that being part of CBS News 24/7 has been uniquely special. It is apolitical. It is fact-based, it is enterprising, it is contextual. It's everything journalism needs to be moving forward. It was a blessing always sharing airtime with you.
Of course, Scott, and I know I sent you an email. It is always amazing having you here because you give us context for every single story that you're on. We are going to miss you, and we wish you the best in whatever comes next. Thank you so much.
And to the behind-the-scenes team.
And a judge just walked through it, concluding that the normal pace of justice was simply too slow to meet the threat this president represents. And Congress is not hesitating. Congress is not forming committees to study the referral or scheduling hearings for next month, or treating this like any other piece of correspondence that arrives on the Hill. Congress is moving with a speed that can only be described as emergency velocity.
Well, developing within the last few hours, a federal judge blocking the Justice Department subpoenas in their investigation into Federal Reserve Chairman Jerome Powell. Those subpoenas targeted Powell's congressional testimony that he had made on the headquarters renovations for the Federal Reserve. Powell claims the investigation is punishment for his refusal to cut interest rates, despite pressure from President Trump. The judge in the case found, quote, a mountain of evidence of retaliation and, quote, zero evidence of a crime. D.C. U.S. Attorney Jeanine Pirro vows to appeal.
Jerome Powell today is now bathed in immunity, preventing my office from investigating the Federal Reserve. This is wrong, and it is without legal authority.
In general, the ruling protects the Fed's independence for now, but Pirro's appeal could reignite the fight over interest rates.
The House of Representatives has activated procedures that were designed for moments of supreme national crisis. They are preparing for an impeachment vote within 72 hours. 3 days. That is the timeline. That is the countdown. That is how urgently the legislative branch is responding to the judicial branch's unprecedented cry for help. 72 hours from now, barring some catastrophic intervention, Donald Trump will be impeached for the 3rd time in his presidency. presidency. And the numbers tell a story that Trump's defenders cannot spin away. The impeachment resolution already has 220 co-sponsors. 220 members of the House of Representatives have already signed their names to a document that will send this case to the Senate for trial. That number is significant for one overwhelming reason. It constitutes a majority. You don't need to whip votes when you already have the votes in hand. You don't need to persuade the undecided when the decided have already formed a governing coalition. The impeachment will pass. The question is no longer whether Trump will be impeached. The question is whether the Senate, once it receives the articles from the House, will do what the first two impeachments could not achieve and actually convict him. And for the first time, there is a real possibility, a genuine mathematical pathway, that conviction and removal is not just a liberal fantasy, but an achievable outcome. This is why Washington looks like a city preparing for war. Security has been tightened to levels that veteran residents of the Capitol have never witnessed. The National Guard has been deployed in numbers that speak to the seriousness of the moment. The streets around the Capitol are in what can only be called crisis mode. This is not normal security posture. This is not routine precaution. This is a city bracing for whatever comes next, aware that the constitutional order itself is hanging in the balance, and that the next 72 hours will determine whether it holds or collapses. What the federal judge has done is shatter a tradition that has stood since the earliest days of the Republic. Judges do not involve themselves in impeachment. They never have. The reasons are rooted in the most fundamental understanding of separated powers. Courts interpret law. Congress makes law and exercises its oversight and removal powers. The two functions are meant to be distinct, kept apart by the structural design of the Constitution itself. For a judge to cross that boundary, to take evidence from a judicial proceeding and hand it to Congress with an explicit recommendation for impeachment, is to acknowledge that the normal boundaries no longer apply because the normal assumptions no longer hold. When the president represents an ongoing threat to the constitutional system, institutions cannot afford the luxury of maintaining traditional courtesies. The judge who took this step understood the gravity of what they were doing. This was not a decision made lightly or impulsively. The judge had been presiding over a federal case against Trump. Evidence had been presented. Witnesses had testified under oath. Documents had been entered into the record. And as the trial progressed, as the picture became clearer with each passing day, the judge came to understand that the conduct being described in their courtroom went far beyond what the criminal justice system alone could address. This was not simply a matter of determining guilt or innocence on specific charges. This was a matter of presidential fitness. This was evidence that spoke directly to whether the man occupying the Oval Office was capable of continuing to exercise the powers of the presidency without destroying the democratic framework that constrains those powers. So, the judge made a choice that will be studied by historians for generations. The evidence was gathered, the testimony was compiled, the documents were organized, and then everything was transmitted to Congress with a formal recommendation that the House exercise its constitutional impeachment power. The judge used the judicial system to activate the congressional system. The evidence that had been gathered for a criminal trial was repurposed as the foundation for an impeachment case. Centuries of judicial restraint were set aside because the judge concluded that waiting for the normal impeachment process to develop on its own timeline would be too slow. Trump could do too much damage in the interim. The situation was too dangerous for patience. When Congress received this referral, the reaction was immediate and electric. This was not a routine communication from the judiciary that could be processed through normal channels and responded to at leisure. This was a four-alarm fire notification from a federal judge saying that the President of the United States must be removed from office with all possible speed. The House leadership understood instantly what they were holding. They began drafting articles of impeachment immediately. They began collecting co-sponsors within hours. They moved faster than Congress has moved on any matter in living memory because they understood that the 72-hour window was not arbitrary. It represented their best assessment of how long the political situation could remain stable before the crisis escalated beyond anyone's ability to control. The longer they waited, the more dangerous the situation became. Trump, faced with imminent impeachment, would have time to consolidate his defenses. He would have time to pressure wavering Republicans. He would have time to use the powers of his office to obstruct the process. Speed was essential. Decisiveness was paramount. The House understood that delaying even a few days could allow the moment to slip away, could give Trump the opening he needed to block the impeachment or manipulate the timing to his advantage. So they committed to 72 hours and they began the countdown. And then the cracks in Trump's political coalition started appearing in ways that cannot be papered over. Tom Tillis, a Republican senator who has never been mistaken for a resistance hero, who has supported Trump through scandal after scandal, who has voted with the president through thick and thin, looked at the evidence that the federal judge had transmitted and made a decision that must have been agonizing. He could not support Trump anymore. The evidence was too overwhelming. The danger was too clear. Whatever loyalty he felt to the party or to the president was overridden by the evidence that a federal judge had formally presented to Congress. Tillis is not a Democratic plant. He is not some secret operative working to undermine the administration. He is a conservative Republican who finally reached the point where the evidence left him no room to maneuver. Thomas Massie reached the same conclusion. Massie, a libertarian-leaning Republican who has rarely been afraid to break with his party but who has also never been part of the anti-Trump resistance, looked at the same evidence and came to the same conclusion. He cannot continue to support this president. The evidence that the judge compiled, the testimony that was given under oath, the documentary record that was built through the trial process, made it impossible for him to maintain his support. And if Tillis and Massie are breaking, if these are the first names we know about rather than the complete list, then other Republicans are wavering in private. Others are expressing concern to their staff and their families. Others are calculating whether their political survival depends on distancing themselves from a president who a federal judge has formally recommended for impeachment. The Republican coalition is fracturing in real time. This is not a slow erosion that takes months to develop. This is a crack that appears and then widens with each passing hour as more Republicans read the evidence, absorb its implications, and realize that defending Trump has become politically and morally unsustainable. They are not just breaking with Trump to save themselves. They are breaking with Trump because the evidence that the judge transmitted is so compelling that defending him becomes impossible. The party that has protected Trump through 2 impeachments, multiple criminal investigations, and countless scandals is finally reaching the limits of what it can justify to itself and to the voters. The 220 co-sponsors represent more than just a number on a legislative tracking sheet. They represent a governing majority that has already solidified behind impeachment. The House doesn't need to persuade anyone. They don't need to twist arms or make deals or offer concessions to get the votes. The votes are already there. 220 members have publicly committed their names to this resolution. That means the impeachment will pass when the vote is called. That means Trump will be impeached for the 3rd time, a mark of shame that no other president has carried even once. That means the articles will be transmitted to the Senate and the upper chamber will be constitutionally obligated to hold a trial. And the Senate trial is where the real drama will unfold. The House can impeach with a simple majority, but the Senate needs 67 votes to convict and remove. Democrats hold 50 seats. That means 17 Republicans must vote to convict for removal to occur. Before the judge's referral, that number seemed impossible. The Republican Party had held firm through 2 previous impeachments. But something has shifted. The evidence that the judge transmitted has changed the calculus. Tillis and Massie are the visible signs of a deeper shift occurring below the surface. Other Republicans are now wondering whether their own political futures depend on being on the right side of history. They are reading the evidence that has been placed before them and realizing that voting to acquit will require them to ignore facts that have been documented in a federal courtroom. The 72-hour countdown is not just a legislative timeline, it is a political pressure cooker. Every hour that passes increases the pressure on undecided Republicans. Every news cycle brings more coverage of the evidence. Every public statement from a Republican who breaks with Trump makes it easier for others to follow. This is how coalitions collapse, not all at once in a single dramatic moment, but through a cascade of defections that gather momentum until the dam breaks entirely. quickly. The judge's referral set that cascade in motion. The 72-hour window compresses the timeline so that the cascade becomes a flood. The National Guard deployment tells its own story about how seriously the government is taking this moment. Troops in the nation's capital are not deployed casually. Their presence signals that the authorities anticipate potential violence, potential unrest, potential attempts to disrupt the constitutional process. Washington is in crisis mode because the constitutional crisis is not theoretical. It is happening right now in the Capitol building where Congress is preparing to vote. The security posture reflects an understanding that what happens in the next 72 hours could trigger reactions that require the full resources of the state to manage. This moment represents something that the founders of the American Republic would recognize immediately. They designed a system of separated powers precisely because they understood that presidents might someday become threats to the constitutional order. They created impeachment as the legislative remedy for executive overreach. They established an independent judiciary that could serve as a check on both political branches. What they may not have fully anticipated was a moment when one branch would have to activate another, when a judge would have to tell Congress that the normal processes were moving too slowly and that extraordinary measures were required. But the Constitution is flexible enough to accommodate emergencies that its framers could not have specifically predicted. The system has resources that even its designers might not have fully mapped. The judge's action is unprecedented, but unprecedented does not mean illegitimate. The Constitution does not prohibit judges from communicating with Congress. The tradition of judicial non-involvement in impeachment is just that. A tradition. It is held for centuries because the circumstances never required it to be broken. Those circumstances have now arrived. When a president's conduct is so egregious that waiting for the normal impeachment process to develop independently would allow irreparable harm to occur, the institutions of government have not just the right, but the obligation to adapt. The judge adapted. Congress is adapting. The system is proving that it can respond to threats, even when those threats take forms that no one precisely predicted. The evidence that the judge transmitted will become the foundation of the Senate trial. This is not evidence gathered by congressional investigators or leaked to friendly journalists. This is evidence that was presented in a federal courtroom, subject to the rules of evidence, tested through cross-examination, documented in the official record. Senators who vote on conviction will be voting on evidence that has already survived judicial scrutiny. They will not be able to claim that the case against Trump is based on hearsay or political attacks. The evidence comes from a court of law, compiled by a federal judge, and transmitted through a formal process that gives it a weight that ordinary political evidence cannot match. Republicans who are considering breaking with Trump now have the cover they need. They can point to the federal judge's referral and say that they are not acting out of partisan animus. They are responding to a judicial determination that the evidence warrants impeachment. They are following the lead of a court that examined the facts and concluded that Congress must act. This cover is politically essential. It allows Republicans to vote for conviction without admitting that they were wrong to support Trump in the past. They can frame their votes as responses to new evidence, to a judicial finding that changed their assessment of the situation. The judge's referral gives them a ladder to climb down from a position that has become untenable. The democracy is fighting back through its institutions. This is the story that will define this moment when historians look back on it. The judiciary, often criticized as the weakest branch, has used its power to defend the constitutional order. The Congress, often criticized as dysfunctional and paralyzed by partisanship, has responded with speed and determination. The three branches of government, designed to check and balance each other, have engaged in precisely the kind of institutional self-defense that the founders envisioned. The system is working the way it was designed to work, not because anyone planned for this specific scenario, but because the principles embedded in the constitutional structure are robust enough to handle challenges that no one specifically anticipated. The 72-hour window will close with an impeachment vote. The articles will pass because the votes are already secured. The Senate will receive the articles and begin its trial. The evidence will be presented. The senators will deliberate, and then they will vote. Whether they reach the 67 votes required for conviction depends on how many Republicans decide that the evidence presented by the federal judge cannot be ignored. The defections of Tillis and Massey suggest that the number will grow. Once the dam begins to crack, the pressure of the water behind it becomes impossible to resist. More Republicans will come forward. More will announce that they cannot support Trump in light of the evidence. The mathematics of conviction, which once seemed impossible, now appear merely difficult rather than unachievable. The voters are watching all of this unfold. They are seeing a federal judge take an unprecedented stand against a president. They are seeing Congress respond with emergency speed. They are seeing Republicans break ranks because the evidence has become too compelling to deny. These images will remain in the public memory when voters go to the polls. The narrative of this moment, the story of how democracy fought back against an authoritarian president, will shape electoral outcomes for years to come. Voters who were uncertain about the strength of democratic institutions will see that those institutions can still function even under extreme pressure. Voters who doubted that anyone in power would ever hold Trump accountable will see accountability arriving through the very mechanisms the Constitution provides. This is not just about removing one president from office. It is about demonstrating that the American system of government retains the capacity for self-correction. The judge's referral proves that individuals within the system can still act with courage when the moment demands it. Congress's rapid response proves that the legislative branch can still fulfill its constitutional duties when the stakes are high enough. The Republican defections prove that partisan loyalty has limits when the evidence becomes overwhelming. All of these are reasons for cautious optimism about the resilience of democratic institutions. The countdown continues, 72 hours. That is all the time between now and the impeachment vote. That is the window within which the House will act, the Senate will prepare, and the country will watch the constitutional process unfold at a speed that reflects the urgency of the threat. The judge has done what no judge has ever done. Congress is doing what Congress must do. The Republicans who are breaking with Trump are doing what their consciences and their reading of the evidence require. And democracy, tested once again by a president who does not respect its limits, is preparing to demonstrate that those limits still hold. This moment will be remembered. The judge who took the unprecedented step will be studied by law students and historians. The Congress members who voted to impeach will be recorded in the congressional record. The senators who vote to convict will be remembered for their courage or condemned for their betrayal, depending on which side of history one stands. But the most important memory will be the collective memory of the American people, who will have witnessed their institutions standing firm against an existential threat and prevailing through the very mechanisms that the Constitution provides. That memory will shape the country's political culture for decades to come. It will teach future generations that democracy is not fragile when its institutions are strong. It will demonstrate that no individual, no matter how powerful, is above the law. It will prove that the American experiment, for all its flaws and vulnerabilities, still possesses the resources to defend itself against internal threats. The 72 hours are ticking down. The impeachment vote approaches. The Senate trial looms. The evidence sits in the congressional record, transmitted by a federal judge who decided that the moment required something unprecedented. The Republicans who have broken with Trump have created a path for others to follow. The coalition that protected Trump through every previous crisis is fracturing under the weight of judicial evidence. And the outcome that once seemed impossible, the actual removal of a sitting president through the constitutional impeachment process, has become a genuine possibility. The countdown has begun. Democracy is fighting back. And the next 72 hours will determine whether it wins.